Well, I'm gonna go ahead and get started. We see the room starting to fill up a little bit. We will be recording this town hall for everyone's informational purposes. So if you think you missed something or want to see something on one of the slides that happens, we'll make sure to have that distributed out via all of our networks and outlets at the city and county as well, if our partners are willing at that time later on. I do want to welcome everyone to our next of our series of town halls we've been doing to try to help keep you informed. This is a pretty unique one. I'm Corey Atkins with the Asheville Area Chamber of Commerce. We are doing this in conjunction with the City of Asheville as well as Buncombe County on the most recently passed non-discrimination ordinance that were passed both at the city and the county levels. We really want to talk to you today about what that non-discrimination ordinance entails, talk about what the compliance factor looks like and the process after that for any sort of complaints looks like. And we have some experts with us here today and folks who've been involved from the very beginning in crafting and implementing that ordinance to give you that overview as well as answer any questions you may have. First of all, we have Branham, who's city attorney for the city of Asheville, Michael Frue, who is senior staff attorney with the Buncombe County, Jasmine Beach-Ferrara, who is county commissioner in Buncombe County. And we also have joining us today, Brook, who is attorney at Patterson Harkavy and also a special advisor to the Campaign for Southern Equality and ACLU-NC, who's helped a lot of municipalities around the state implement these. And Chris is going to walk us through some more of those details about the ordinances and what they do and don't do later on. But first off, if we can go to the next slide, please. I would like to introduce Jasmine Beach-Ferrara, who is the Buncombe County Commissioner for Buncombe County, and to talk about, give us some context about the overview of what the non-discrimination ordinance is, how it came to be, and give us some context for what the needs are in the county, and then we'll move to the city after that. Jasmine, thanks for being here.
Great. Thank you so much to Corey, and thank you to everyone who has joined us today. I've very much appreciated the opportunity to be in ongoing conversation with members of the chamber and chamber staff. Honestly, for many years, as we have discussed what it would look like to propose and pass a non-discrimination ordinance here locally. And I'll just provide a bit of context, both from the community level, and then talk a little bit about the contents of the non-discrimination ordinance that was passed and that will go into effect July 1 for Buncombe County. Just to start with some of that background and context, basically the intent of a non-discrimination ordinance is to provide protections from discrimination for communities that are vulnerable to discrimination. Under federal and state law, some protections, or many protections already exist for many minority communities, including around issues of race and gender. For the LGBTQ community in particular, it has been a slow and steady march towards achieving the threshold of full equality under the law. Right now, there are not protections under state or federal law for LGBTQ folks in North Carolina in the areas of public accommodations and in the areas of employment discrimination for employers who are under the size of 15 employees. So what non-discrimination ordinances do, and I should say that they have passed in over 300 communities across the country. Some have been on the books for decades in other communities. What these non-discrimination ordinances do is create that shelter of protection at the local level so that if and when incidents of discrimination occur, there are ways for those to be reported and addressed rather than there being sort of no mechanism in place to do that. In addition to that very concrete impact, which is the primary reason we advocate for the passage of non-discrimination ordinances, there's other things that happen when these pass. One of them is that they have a teaching effect and an effect of communicating values around inclusion and fairness and dignity for all being community values. And another is that we know that policies like this are not just good for people's lives, not just good at the level of equitable communities, but they're also good for business. And that's why we've seen so many large corporations actually far out as pace setters in establishing inclusive non-discrimination policies and practices within their own businesses. It's part of how we attract and retain diverse, talented workforces. It's part of how we attract and retain diverse customer bases. And from an economic development perspective, it's part of how communities like ours can be in dialogue with and attractive to larger employers who are looking for places to expand their operations. So there's multiple reasons that are sort of driving this. In North Carolina, the story's been a little bit more specific and winding. A law was passed called HB 142 that came on the heels of the very controversial HB 2 addressing and discriminating against LGBTQ folks. And one provision of HB 142 said that local municipalities could not pass non-discrimination ordinances. In December of 2020, that provision of HB 142 expired at the state level, and there was no effort to extend its lifespan. And what that basically did was sort of lift that barrier for communities in North Carolina to begin discussing and passing non-discrimination ordinances. In the period between January and now, 8 communities across the state, towns, cities, and counties have passed non-discrimination ordinances, providing protections in the area of public accommodations and employment. And we expect to see more following suit. So I'm grateful to everyone who is part of dialogue and conversations in the process of Buncombe County getting to this place. That included, of course, many members of the business community, faith community, community members. It included folks with varied perspectives on this. As part of this process, just to give a bit of context, we addressed this issue at 4 public meetings of County Commission. We also held an open community forum where there was very robust and varied conversation about it. And the effort has really been to meet people in dialogue and to reinforce the core aims of this NDO, which I'll talk about in just a moment. But the core aims, again, are to reinforce those community values around fairness, dignity, inclusion, and equity, and also to provide concrete ways to address incidents of discrimination if and when they occur. There is a long trail of national data documenting the incidence and prevalence of discrimination in employment settings and public accommodation settings for LGBTQ folks in particular. We know that transgender folks are at even more elevated risk for experiencing employment discrimination and experience in public accommodations. And we also know, unfortunately, and this is certainly one motivator for us, we know recent data showing that when LGBTQ youth experience discrimination, their risk of attempting suicide actually increases. So there's all sorts of motivators at the level of sort of the human side of this for why we worked hard to get this passed. So just briefly, and I will, if I'm able to share the link in the chat, I will do so. If not, maybe chamber staff can do so. But basically share a link to the text of the Buncombe County Non-Discrimination Ordinance. And just sort of basically walk through the core elements of it, and there'll be time for questions later on about any piece of this. The ordinance provides protections reinforcing existing federal and state protections, and then also establishes protections at the local level around natural hair or hairstyle, sexual orientation, and gender identity or expression. And these apply in the areas, again, of employment and in the areas of public accommodations, which basically means places where people receive public services or access public goods, such as a store or a facility that folks would access. As we talk about employment, this basically means that folks cannot be discriminated against in the hiring process or during their terms of employment or the conditions of employment on the basis of having any of these identity characteristics. There are exemptions that are named within the Buncombe County NDO. These are exemptions that are actually created and carved out under federal law, but we thought it was important to delineate them within the NDO so folks understand that they're there, and they particularly address some of the intersections of how religious organizations approach hiring and the protections that religious organizations have in terms of their ability, for instance, to hire people within their faith tradition and to consider that as a factor within the hiring process. At the level of public accommodations, the simplest way to put this is basically it means that people will be served and treated with fairness and dignity and have access to public accommodations while they are out in public, shopping, traveling around in public, those kinds of things. Based on the survey responses that the Chamber conducted, the vast majority of Chamber members reported that you're more or less already complying with this non-discrimination ordinance, both in the areas of employment and public accommodations, and don't see it impacting the way you do business. And we expect that to be the case for the vast majority of covered entities within the county. If there are folks out there who want to verify that you are in compliance or who have questions about how to comply, or who would like to take a step beyond compliance and actually think about what it means to create a more inclusive environment. There are lots of community resources through the Campaign for Southern Equality and Equality North Carolina on that. Later, we will talk about sort of the enforcement side of this in some more detail, but I do want to lift up a couple pieces. One is that the spirit of this ordinance, like most ordinances that are passed at the local level, is not punitive in nature. It is about education, mitigation efforts, and efforts to reach conciliation and resolution to fix the problem. So that if an incident of discrimination is reported and through a due process investigation is found to have occurred, there are multiple opportunities for that to be addressed. If that doesn't happen, there are civil penalties that are included, very similar to the way other ordinances are structured. So I hope that provides an overview. Again, we'll talk in some more detail about the reporting and enforcement process later on in the presentation, but I want to turn things over now to Brad Branham, the Asheville City Attorney, who will talk about sort of how the city's NDO functions.
And Jasmine and Brad, do they take effect on the same date, and what is that date? We failed to mention that up front.
Great question. Yes, the county's takes effect on July 1, and I will let Brad fact check me on when the city's does.
All right, thank you, Jasmine. Go ahead, Brad.
Perfect segue, and I will say that the city's ordinance takes effect on July 1st as well, so it is a consistent process throughout the county on this. And with that being said, Corey, thank you for having me as well. I can start out by saying that Commissioner Beach-Ferrara has made my job incredibly easy because she has already highlighted not just some of the important elements of the ordinance that exist for the county, which is mirrored in many of the provisions that have been included in the city's ordinance, but also expressed a lot of the rationale behind the decision-making process. I never try to speak too much for the city council on these things, but I can tell you without a doubt, there was a great deal of consensus that it was the city's role to fill this gap and to provide these protections for those members of our community where current state and federal law did not yet provide those sorts of basic rights. So we felt very strongly this was a way that local government could step in and provide some protections, which we were happy, at least here locally, to believe that many of those were being self-imposed already by the business community, and those values being shared by many of the residents of Asheville and Buncombe County. So with that being said, let me give you just a little bit of background on what the city's ordinance includes. And again, I will say that it is extraordinarily similar to what the county has passed. This was a conscious decision to make sure that we had consistency, not just in our ability to enforce these ordinances, but for the public to be able to know when you're crossing over from the city jurisdiction to the county, that the same rules are going to apply regardless of where you are. So the purpose of this ordinance, as the commissioner has already stated, is to prevent discrimination, specifically in areas that were not already covered by state and federal law. And we focused on two areas: public employment, private employment and public accommodations. And some of the differences you may see in the employment context is existing federal law often applies to employers of larger numbers of people. We wanted to make sure that this applied broadly, and therefore anyone with even one employee is under the same obligations here in Asheville and in Buncombe County. Public accommodations, also think of any sort of a business that provides some service or good to the public, and that may include an Airbnb, a restaurant, a shop, or any sort of service particular industry. Now, we also in the city wanted to align ourselves with Buncombe County. So you will read these two ordinances and think that they are, as they are intended to be, mirror images of one another. Other than some necessary differences with regard to the staff that are utilized to enforce and oversee these ordinances, the application and the restrictions are almost identical. Now, in Asheville, we are very, very focused on not just advancing our goals of racial equity and inclusion within city government, but also in the city as a whole. And we felt this was another excellent tool to begin moving that out into the community that we feel is very accepting of that. As the commissioner mentioned, this all really stems from a previously passed law in the General Assembly, House Bill 142, which set up some limited time frames where local governments could not regulate these things. But when that expired in 2020, late 2020, local governments, both at the county level and the city level throughout the state, began to look very hard and pass some of these anti-discrimination ordinances. At this point, we have seen similar ordinances being adopted in Chapel Hill, Carrboro, Hillsborough, Durham, Greensboro, Orange County, Mecklenburg County, Buncombe County, obviously, in Asheville, and we think that more to come just within the state of North Carolina. An important part of the city's ordinance, which I don't know has been mentioned yet, beyond just the regulation of discrimination in public accommodations and private employment, we've also included provisions whereby the local government would provide assistance to those individuals who might be experiencing discrimination in housing practices as well. There is already a very robust state program with the State Human Relations Commission that deals directly with this kind of discriminatory practice. And we want to provide a conduit to be able to assist those individuals as well, not based upon our local laws, but under the state law, which already exists here. So you'll see some information in both the city and the county ordinance about that as well. As is already mentioned, the goal of these ordinances is not to set up either a criminal structure or even a primary civil fine structure, but rather one where we attempt to try to address any problems that might arise through a process of persuasion, communication and mediation, and hopefully entering into voluntary agreements to cease and avoid any additional activities that might run afoul of the ordinances. There are some civil penalties in place if need be. However, our goal is to primarily utilize this as a tool to educate and a tool to bring everyone into compliance voluntarily. Now, as has already been mentioned, we have two primary areas in the city ordinance, that of regulating private employment for anti-discrimination and public accommodations. I've already mentioned a little bit about what those things include, but let me also say that the ordinance on both the county side as well as the city incorporates several exemptions into that. We've already mentioned some religious exemptions, which if Chris is able to join us, can talk a little more thoroughly about some recent Supreme Court decisions that have come down that may or may not have any effect on these particular ordinances, but we believe they do not. But we've also included several exemptions which primarily help us align ourselves with existing state and federal law. So it's important to note that although these cover a new area, which is not currently defined in state law, we've made sure to include those exceptions that already exist within our legal system so as to not contradict any existing law that's already on the books. As has already been mentioned, this is primarily an educational system, a voluntary compliance system, but we do have a process both in the city and county to provide for civil penalties. None of this is criminalized, but civil penalties are available if necessary, and that would only be implemented after the process of voluntary persuasion has been exhausted. It is our hope that people will utilize that system to its fullest extent in order not just to provide the educational service, but to reach these voluntary settlements which do not carry any additional civil penalties whatsoever. We have included in both the county and the city's ordinances a robust due process procedure to allow people to appeal any sort of determinations that are made to multiple levels so that we can ensure that anyone who's going through this process will have ample opportunity to argue their position and make sure that it is heard and decided on in a fair and impartial way. Now, as I'll close out my part of this, just to say again that the city's ordinance, although already adopted, does not go into effect until July 1st. So the county and the city will have these implemented on the same day. And it is our hope that this additional period allows these sorts of community events to provide the kind of education that we're hoping to give today, to allow people to begin getting up to speed on what it means to be compliant with this ordinance, both at the county and the city level, as well as city staff and county staff preparing themselves to be able to receive any complaints that might come in. So that gives you a basic overview. We will talk a little more in just a few minutes about what the enforcement and oversight procedure looks like. But until then, I think I can hand it back to, if Chris is not here, we may be able to talk a little more just generally, Michael and myself, perhaps, about some of the legal ramifications, but I'll give it back to Corey to see where we stand.
Yeah, he's joined us. Chris has joined us. So thank you for that, Brad. Thank you for that additional overview and letting us know what's going on in the city. So for those of you watching, we've learned the why, when it's going to be implemented, and some of the what, but you probably have a lot of questions still pending out there. And luckily we have our legal expert here, Chris Brook with Patterson Harkavy, as I mentioned earlier. He served as advisor to the Campaign for Southern Equality as well as Equality-NC. Has been working on this issue across the state, and we're lucky enough to have him here with us today to help at least get what's probably some of your main questions out of the way up front. But I do encourage you as we go along, as after this we'll talk about enforcement briefly and then get to a Q&A. Please type in any questions or comments you have in the chat function, and I'll do my best to facilitate that discussion as we go along. But before that, Chris may already be able to answer some of the questions you have. And again, thanks for being here, Chris. I'm going to let you take it away from here.
Thanks so much, Corey. I appreciate it, and wonderful to hear Jasmine and Brad's earlier comments, which very much tee up what I'm going to be saying today. As Brad alluded to, there are 9 cities and counties at this point that have adopted non-discrimination ordinances across the state of North Carolina. And you heard a little bit from Commissioner Beach-Ferrara about sort of and from Brad as well, about the policy rationales for adopting these ordinances. I'm going to talk a little bit about how why they're legally necessary, how they fit in the state and federal legal regimes that we have in employment and public accommodation. And then, as Brad alluded to, I'm going to talk a little bit about the Supreme Court's recent decision from Thursday in Fulton. Thank goodness it did not come down this week, as we would have been scrambling trying to read it and then respond to it exceptionally quickly. But if we could move along to the next slide, I have just a few slides here that are going to talk us through why non-discrimination ordinances are necessary from a legal standpoint. So here in North Carolina, we don't have any substantive protections safeguarding employees against discrimination in the workplace. And we have very limited protections safeguarding individuals from discrimination in public accommodation. There are some protections, especially in regards to protecting folks from discrimination based on being differently abled in our statute, but there's nothing that offers sort of comprehensive protections in public accommodations. This, of course, raises the question, and some people might know the answer to this question, some people might not. What is a public accommodation? And I've grabbed Buncombe County's definition. I believe Asheville uses a similar definition, which is sort of very standard definition of what a public accommodation is. And it's any place, facility, store, or other establishment which supplies the accommodations, goods, or services to the public, or which solicits or accepts the patronage or trade of the public. So, boiling that down a little bit more into common parlance, if you are open to the public, if you are serving the public, if you are a restaurant or a hotel that anybody can walk in and get service from, you're a public accommodation. So if we move to the next slide, at the federal level, there are some protections in the public accommodation and employment space. So if we start with employment, Title VII, as I'm sure a number of y'all who have joined us today know, prohibits discrimination on the basis of sex in private employment. Recent Supreme Court decision, 6-3 decision authored by Justice Neil Gorsuch, Bostock, says that discrimination, and this is a Title VII case, so dealing with discrimination in the employment context, says that discrimination based on sexual orientation or gender identity necessarily involves discrimination on the basis of sex. So that means that Title VII already prohibits discrimination on the basis of sexual orientation and gender identity in private employment. However, Title VII only applies to employers with 15 or more employees. So there's a sizable, substantial, sort of small employer gap that exists out there. Title II also provides some protections in public accommodations, for instance, prohibiting race discrimination in public accommodations. So you can't deny someone access to your restaurant or your hotel based on race. It does not include a prohibition on sex discrimination, however. So therefore, it doesn't also include a prohibition on discrimination based on sexual orientation or gender identity in the utilization of public accommodations. So when you look at the state and federal level, what you see is a little bit of a patchwork. There are gaps for the LGBTQ community in regards to employment, where employers who have fewer than 15 employees are not prohibited from engaging in discrimination based on sexual orientation and gender identity. And there really aren't protections at either the state or federal level protecting the LGBTQ community from discrimination in public accommodations. And this is why the NDO from a legal standpoint is necessary. This is the gap that these non-discrimination ordinances are seeking to fill. So that's just a little bit of the background about the legal lay of the land and how these ordinances fit within the state and federal broader context. So if we could go to the next slide, please. Some frequently asked questions, right? And Commissioner Beach-Ferrara alluded to HB2, Brad alluded to HB 142 earlier. So one of the questions that we hear a lot is, what impact do non-discrimination ordinances have on bathrooms? And the answer is, I put an exclamation point. Emphatic, none. They do not have an impact on bathroom regulation. HB 142, while as Brad referenced, had a time-limited preemption on local regulation of public accommodation and private employment that has since sunset. It retains HB 142, North Carolina General Assembly authority and control over bathrooms. It says state agencies, boards, et cetera, political subdivisions of the state, which includes local government, are preempted from regulation of access to restrooms, showers, changing facilities, except in accordance with an act of the General Assembly. So the upshot of this is that businesses like the ones that you run in Asheville and Buncombe County can regulate bathrooms as they see fit and have inclusive policies allowing folks to utilize restrooms based on their gender identity. But cities and counties cannot regulate bathrooms beyond what the North Carolina General Assembly has said. So when somebody asks you what impact non-discrimination ordinances have in regards to bathrooms, the answer is very, very straightforward. They don't have an impact on bathrooms. So if we could go to the next slide, please. Another question that we hear quite frequently: what impact do non-discrimination ordinances have on religious institutions? These non-discrimination ordinances are not aimed at impacting the operations or hiring practices of religious institutions. And what we've seen in these 9 ordinances that have been adopted so far is sort of an explicit way of making that plain and then an implicit way of making that plain. I think they're sort of different paths to the same destination. Buncombe County adopts an explicit and regime of exemptions that very, as Commissioner Beach-Ferrara noted, very specifically enumerate the exemptions from the non-discrimination ordinances. One of them is 1042.3C5, says nothing contained in this ordinance shall apply to a religious organization with respect to the employment of individuals of a particular religion to perform work connected with carrying on by those organizations of their activities. Chapel Hill does it in what I've termed sort of the implicit way of going about it. They say this article shall be construed and applied consistent with other laws. The reality of the situation is that religious institutions constitutionally have a great deal of leeway and authority to decide who they're going to hire. They're allowed to hire co-religionists for jobs within their churches, synagogues, mosques. And similarly, as we're going to discuss in a moment, just talking about Fulton, as a general matter, churches are not engaged in operating public accommodations because they're not offering, as a general matter, services along the lines of restaurants, hotels that are generally available to the public. So if we could go to the next slide, that's a good segue into the impact of the recent Fulton decision. So this was a decision that came out on Thursday. It was called Fulton versus City of Philadelphia. Question that is immediately what we were looking at Equality North Carolina and Campaign for Southern Equality is what impact does this have on non-discrimination ordinances? And as Brad alluded to earlier, the answer is a pretty clear no. What was an issue here and what the Supreme Court held is that they unanimously held that Philadelphia could not offer exemptions from its anti-discrimination policy to secular foster care placement agencies that they did not also make available to Catholic social services, which is obviously a religiously affiliated foster care placement agency. In this instance, they had exemptions that were available and had been, were accessible for secular folks. They did not make an exception based on the religious beliefs of Catholic social services related to placements of foster children with folks in same-sex relationships, folks who are not married. And the Supreme Court unanimously held that you can't offer those exemptions to secular institutions without offering them to religious institutions. So it's a very narrow ruling based on these facts. Chief Justice Roberts writes the majority opinion, and he reiterates an observation from a recent public accommodations case that you might be familiar with, you might have heard about a few years ago, Masterpiece Cake Shop, which really is much more of a public accommodation, a traditional public accommodation that was, a cake shop. So, it was open to the public. If you wanted the cake, if you wanted to have a cake made for your wedding or for your special event, you could go in there and it was available for your use. So Chief Justice Roberts highlights and reiterates from, one of the key things from Masterpiece Cake Shop, which is that, our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. So where Chief Justice Roberts says that programs like Philadelphia's foster care placement service cannot be upheld because they don't treat religious and secular institutions the same way. This case, that passage, but also Masterpiece Cake Shop, both seem to nod at truly neutral non-discrimination ordinances being constitutional. Chief Justice Roberts also notes that this foster care placement agency and folks who engaged with it and folks who do these placements, are not public accommodations. He says they involve a customized and selective assessment that bears little resemblance to staying in a hotel, eating in a restaurant, or riding a bus. The hotel that you stay in isn't deciding, whether you meet particular specifications to stay in their hotel. The folks who are letting you into the restaurant aren't making those sorts of assessments about whether you're going to be able to sit down and have lunch there. So that makes it very different than the public than the foster care placement agencies, which are making those sorts of assessments. So again, pretty straightforward answer here, which is what impact does Fulton have on non-discrimination ordinances? And I think the answer is none. So with the final slide, I'll just, I know we're going to have some questions here that Corey's going to help us to moderate. I'll just put my email up there in case anybody does have questions going forward. After we're done today, feel free to shoot me an email. But again, I just want to thank everybody for joining today to learn a little bit more. And I also want to thank Asheville, Buncombe County, and the Asheville Area Chamber of Commerce for really engaging in this sort of educational program so folks can know what these NDOs do and do not do and how they fit into state and federal law and that broader context.
Yeah, and thank you, Chris. That really, I learned some stuff from that slide, certainly, and I've been actively engaged in this from the beginning, but I definitely learned some stuff. So I'm sure a lot of other people did that are watching here today. So thank you for lending your expertise to us and giving us a little bit more detail about what is and is not in these ordinances. really the main purpose of this town hall is for us to X out any unfounded rumors or anything that isn't truthful. And we really want our membership and our broader business community to just be educated and make sure they understand what is and isn't in it. And I think that I think y'all have all done a good job so far laying that out. So now that we know what is in it and what's not, let's talk about what happens if someone files a complaint against you as a business owner. What's that process look like? Are they different in the city and county? And what resources are available? And I guess, Jasmine, it would be appropriate to let you or Michael walk through this next part. I'll allow either one of you to.
Sure. Maybe I could just provide a little bit of context, and then Michael, if it works, have you walk through this process?
Sure, I'll give it a shot.
Okay, great. Thank you. Let me just start by kind of describing the status quo, and then that will segue into how that will change on July 1 when the NDO becomes effective. One part of the status quo is that I would say the vast majority of covered entities in Buncombe County are already complying with the letter and spirit of the NDO before it even goes into effect, because of the values driving that work, and also because it's good common sense business practices to do so. I will also say that there are incidents of discrimination that are reported and occur within Buncombe County. At the community level, there's I would say a steady level of reports of incidents of discrimination and harassment that happen in employment context. Sometimes it's at the hiring process. Sometimes it's what's happening during the conditions of employment, and at the level of public accommodations and at the level of housing. So we know those experiences happen. And the question becomes, what happens once that happens? And right now, there's really not much recourse for either an individual to address that, or much recourse or structure for how a covered entity could respond and correct to that. If it's not covered under federal law, and if someone doesn't have the resources and bandwidth to pursue the sometimes cumbersome process of reporting anything under federal law through the EEOC or HUD, for instance, the experiences kind of happen. They create negative impact, they create reputational impact, but they don't ever get addressed or resolved. And one of the primary purposes of the NDO was creating a system and structure that's consistent, transparent, informed by due process, and has resolution, through which these reported incidents can be reported in the first place at the county or city level, and then addressed. And the goal, of course, as has been reiterated many times now, is mitigation and to reach some form of resolution, as is the case with other local ordinances when we think about noise issues, for instance. And the goal is also, I hope, to help our community move forward. Sometimes these incidents happen and they're never resolved, and the stories linger for many, many years in the lives of the people who are impacted and surrounding the reputation of the institution or business at which the incident happened. And this creates a pathway through which there can actually be repair and closure, and a chance to move forward as well. So with that, I'll turn things over to Michael. I want to just take a moment to thank staff at both the county and city level. Reporting and enforcement systems did not exist prior to the passage of the non-discrimination ordinance, and there's no small thing to develop a system like this, but I think it helps us in a number of different ways, as the county certainly is embarking on a much more robust approach to our equity work overall, and that fits into this piece. So I'll turn things over to Michael to walk us through the county's approach.
Thank you, Commissioner Beach-Ferrara. On the county level, first off, my office has been working with Brad's office at the city, not only to make sure that our ordinances are basically mirrored so that there's no difference between jurisdictions, but that the enforcement and investigation processes will also be very similar. We have there'll be an online form to fill out if that is your choice to make a complaint. You could also do it by the mail, print out a form, fill it out, send it in. We'll have an equity officer in place to review and accept those complaints to send a notice of complaint and response forms, and hopefully that'll be electronic also in the near future. There'll be a system in place to investigate, to gather information. And again, to touch on what Commissioner Beach-Ferrara and Brad have all mentioned, the idea is hopefully to find some middle ground to provide an education opportunity to reach conciliation. And there'll be a mechanism in place to have a written agreement between the parties to ensure that that in any agreement, any resolution is in writing, it would have the force and effect of a contract between the parties. We want it to be more than just an agreement to disagree, but an actual resolution and closure for any complaint. I want to point out that complaints are not going to be just a simple matter of public record. There'll be an investigation file. They'll be preserved in case there's a trial necessary. We hope that's not the case. Again, we want to educate the community and educate persons on their conduct. When I spoke with the Orange County Attorney's Office, they've had a civil rights ordinance in place for many years. And the lady that generally enforces that has informed me that there's really maybe 20 down in Orange County, they're a little smaller, about 20 complaints per year that are found to be justified. And none of those end up in court, and almost all of them have a favorable resolution through education. A lot of times that's just simply a matter of how you conduct an interview in private, questions that are out of bounds for any interview. And again, it's a matter of education. So let me turn it over to Brad if you have anything to include there.
Thank you, Michael. And I think the most important thing to reiterate here is it is our hope that if not immediately, after a short period of time, that we have no complaints, that this is a dust gathering ordinance that was a wonderful start to a process that then becomes self-fulfilling within our communities. We do, as we have said multiple times, plan to focus primarily on a process that allows people to file these complaints, but then to, as part of the investigative segment, to really focus primarily on engaging with the parties to be able to provide any education that's necessary and to help facilitate a process of mediation and persuasion to reach some conciliation that can be entered into as a binding agreement that would not be in place instead of criminal penalties or civil penalties, but it's the primary goal to bring us into compliance, because we do believe that, as has been said, there are some complaints, but we think it is the minority. And we think in many of those cases that people are willing and desiring of doing the right thing and complying with these ordinances, but maybe need a little more information about what it really looks like to be in full compliance. Some of these things are results of longstanding practices, which maybe not a lot of thought goes into on a day-to-day basis, but maybe reaching into that area where discrimination is perceived. And the reality is we want to try to provide people with the same education that we believe has helped many people within the local government sectors increase our own compliance with racial equity and inclusion. So we, like the county, will also have an online system that can be reached through the city's website. Everything within the city is going to be handled through our Office of Equity and Inclusion, where we will have a staff that is going to receive those complaints that can be filed both online or in writing, in person, or through the mail. And they will do an investigative process, again, trying to gather all of the necessary information. These complaints will be reviewed on what we call a reasonable basis. What that typically means is that they are not utilizing a criminal standard of beyond all reasonable doubt, which we hear so much on television about, but trying to determine, is it more likely than not, based upon the information, that discrimination did occur. If we reach that point, we will then engage in that process of trying to reach a conciliation agreement mutually and voluntarily amongst the parties to resolve the issue permanently, but without any additional penalties. At any point, any sort of determinations can be appealed by either party. And if a business is determined through that process to have reasonably violated the ordinance, they will have the option to appeal directly to a panel, which will consist of myself as city attorney, the city manager, as well as the city's human relations director. We hope that this will provide the necessary second look, if needed, to be able to determine whether or not a true discriminatory practice has occurred. It is only after all of this has failed, in the hopefully extreme minority of cases, that we do have the ability to issue some civil penalties for those who are continuing to violate knowingly the ordinance in some way, shape, or fashion. We've kept those penalties fairly consistent with other civil penalties, not just within the county and the city, but throughout the state. They are set as $100, but each violation can renew each day. So those penalties could add up if not resolved over time. Again, it is our hope that those never come into play and that we are able to receive almost no complaints, but resolve those complaints that we do receive through the voluntary process. But we have included those due process measures in place to ensure that this is a fair process throughout any sort of complaint that's received. And everything, again, Form 1 all the way through the end process will be available online, and each will contain a fairly robust explanation of your rights throughout the process. So feel free to take a look within the next, hopefully, week or so at the city's website, because all of those forms will be available for your review as well at any point. With that said, I think I'll hand it back to either Michael, if you've got anything else to add, and if not, to Corey.
And I just wanted to follow up with that, Brad. Thank you. And just point out that the county has the same due process system in place for its ordinance. So any decision of the equity officer could be appealed to a 3-person panel for a second look before any civil penalty may be imposed. Thanks.
Yeah, and I appreciate Desiree walking through the rest of the slides on the website. I like the timeline one because I think it really gives people a sense of someone's not just complaining about you and you've got $100 fine on your doorstep the next morning. I mean, I think there's really a thoughtful laid out process here. It really resembles a court process, as Brad and Michael, as you know, of the 30-day response time and 10-day appeal process. So I really appreciate, and I know a lot of the business community appreciates the fact that we've built in this resolution timeline. You know, honestly, it gives a time for, heads to cool down too as well, which always usually helps in resolution cases in my experience. And so I think that's great. But if you want to know how to do this, we're walking you through some of the website features here from the county side. I know the city side will resemble this, but you can contact, and there's a report section. It'll walk you through the process, and here's what the online complaint form looks like for those folks who would fill it out, sort of the beginning part of it. And so thank you, Des, for walking us through that. And thank you, Michael and Brad, for adding to that and letting us know about the timeline. Well, I encourage you all to to type in any questions you have. We have a few minutes left for Q&A as you go along. Hopefully a lot of these questions have been answered if you had any when we started. I know it's been a lot of information in a short period of time, but again, we want to make sure everyone really fully understands what this ordinance does and doesn't do, and how the process would go if something were to, in Brad's words, the minute possibility that there is a complaint, or the extreme rare case of a complaint, as we also hope that you kind of know what to expect in that situation. We do have one question for the panelists. This might be more for the county or city at this point. Has there been language articulated stating that as an employer, he or she or we are adhering to the NDO? So in other words, for use on recruitment platforms, employee handbooks, websites, those kinds of things. I guess similar to an EOC policy statement is probably what I would guess. Has there been language formulated for that for employers to use on those kinds of materials?
I'll start off. Not yet. That's certainly something we could look at, and certainly in other communities see employers adding language on saying, in addition to EEOC guidelines, we are comply with the non-discrimination ordinances in effect in community X. So that's something that could be done. And in some ways, this is a moment to pivot into something I did want to make sure to cover. we wanted to make sure that y'all really had a strong foundational presentation about the legal and policy and technical sides of this. But there's another piece that I want to make sure to lift up, and it's sort of embedded in why we talk about the NDO being good for people and community and business, is that one thing we know is that when people feel free to be who they are and to show up as they are, they do better and they perform better as employees, as leaders. They participate more fully as customers. And that's everything from folks feeling like they could talk about what they actually did over the weekend with their family and who their family is, to being able to dress in a way that corresponds with their gender identity and know that they will be affirmed and not harassed as a result of that. So the reason that I pivoted into this was saying that in addition to the more technical ways that employers can communicate about this compliance, there are lots of other things that can be done that help support an environment that reinforces this. And we know that whether that's employee resource groups, for instance, or signage that reinforces inclusion. And those are the kinds of things that are difference makers for those who may be interested in certainly hitting the threshold of compliance, but taking it a step further and saying, we really want to create a work environment and an environment for our customer base where these values are being affirmed. And that's something that at the community level, CSE and Equality-NC are available as resources on. But there's also lots of great models from the business community locally and in other parts of the country around what that can look like.
Thank you, Jasmine. Michael, you mentioned preserving the record for the court. I'm assuming that you're referring to a situation where the employer is appealing the imposition of a fine or the person who feels discriminated against is appealing to a court. Is that what you mean by that?
Essentially, I mean, we just, I like to say we prepare for the worst and hope for the best.
Thank you. Chris, this is probably for you. Does the ordinance apply to nonprofit organizations that are not religious based?
Well, I think Michael and Brad would perhaps have the best context in regards to that. But I think it would not necessarily turn on your nonprofit status, but would turn on whether you fit within the definition of a public accommodation. So whether, in Buncombe County's instance, whether you're a place, facility, store, or other establishment which supplies accommodations, goods, or services to the public, or which solicits or accepts the patronage or trade of the public. So if you're sort of open for business to the public, the nonprofit status is not going to be determinative. It's really whether you're open to and serving the public. But I don't want to step on Brad or Michael's toes there, but that's the way that I would sort of view it.
And what about the private employment side of that? Nothing. Whoever wants to answer.
Corey, I may be able to answer that. I would agree. That's absolutely right. The distinction is not made in at least the city's ordinance. I don't believe the county's either, about whether or not you are for-profit or nonprofit. The definition in the ordinance for employer is any person employing one or more persons within, for the city, it's within the city, or any person acting in the interest of an employer, directly or indirectly, including any employment agency. With regard to public accommodations, we've already read that definition, I think, a few times, but again, it does not draw a distinction between for-profit or not-profit. It is those just doing business, basically, in the public, open to the public, and providing goods or services or accepting patronage.
Okay. And this question probably is for you, Michael. Since they are in Buncombe County, does the county's NDO apply to small town jurisdictions such as Black Mountain, Weaverville, Woodfin, Biltmore Forest, Montreat, and those areas?
Yeah, county ordinance does not automatically apply within a municipal jurisdiction without that jurisdiction's consent or request. So not automatically.
So they would have to essentially opt in, such as, or do similar to what City of Asheville has done and sort of duplicate it in their jurisdiction?
Exactly, yes.
Okay. All right. I believe that's all the questions we have, unless anyone else has any others in the audience that I've missed. Thanks for those questions. Those are really good ones that we didn't distinguish those things during our conversation. So there were some really good questions to go over. Please join me in thanking our panelists for being here and taking time to be with us here today. Brad Branham, City Attorney for the City of Asheville, Michael Frue, Senior Staff Attorney for Buncombe County, Jasmine Beach-Ferrara, Buncombe County Commissioner, and Christopher Brook, who's Attorney at Patterson Harkavy and Special Advisor to Campaign for Southern Equality and Equality-NC, for shedding light on this important non-discrimination ordinance today. Hope you got plenty of all of your questions answered. Hope you can communicate this to your networks of folks who weren't able to be here. We have recorded this session and we will be sharing it out on all of our social media platforms as well as our website. So if you did miss something or want to go back and catch something that you may not have been listening fully to or missed an important point on, we'll make sure that you have access to that shortly as soon as the video uploads. But thank you all again for being here, and we appreciate your time today. Thanks so much.